Case 61, Guille v. Swan. We find ourselves in the New York Supreme Court in the year 1822. Facts. Swan sued Guille in the Justice's Court in an action of trespass for entering his land in a balloon and treading down his roots and vegetables in a garden in the city of New York. When he descended, his body was hanging out of the car of the balloon in a very perilous situation, and he called to a person at work in Swan's field to help him, in a voice audible to the pursuing crowd. After the balloon descended, it dragged along over potatoes and radishes for about 30 feet, when Guille was taken out. When the balloon descended, more than 200 persons broke into Swan's garden through the fences and came on his premises, beating down his vegetables and flowers. The damage done by Guille with his balloon was about $15, but the crowd did much more. The plaintiff's damages in all amounted to $90. Swan sued Guille for trespass. Guille argued that he was responsible only for the damage done by himself and not for the damage done by the crowd. Moreover, he argued that the damages he caused were involuntary, while that done by the crowd was voluntary, therefore no union of intent. The judge instructed the jury that Guille was answerable for all the damages done to the plaintiff. The jury accordingly found a verdict for him for $90, on which the judgment was given, and for costs. So what's the issue? Whether it was appropriate to hold Guille liable for all the damages, as opposed to also finding that the crowd that came to his aid were co-trespassers. Holding. The court held that Guille was responsible for the entire chain of events, flowing from his decision to fly. What a huge burden the court created for the aviator. Reasoning. There are various definitions of trespass under the law of every state, but Black's Law Dictionary offers a useful and uncontroversial one. An unlawful act committed against the person or property of another, especially wrongful entry on another's real property. It is axiomatic that trespass is an intentional tort, but the Guille court sidesteps this, focusing not on the aviator's intent to go onto the property of another, but on his intent to fly, and his responsibility for everything that could result as a result of that intention. If the act caused the immediate injury, whether it was intentional or unintentional, trespass is the proper action to redress the wrong. Thus, the court applies a foreseeability test more akin to a traditional negligence claim. At the time of the Guille case in 1822, the common law recognized the concept of trespass, but had yet to apply it to a situation that was probably thought impossible, where somebody flew over another person's property without authority or consent. That is what is so interesting about the Guille case. It is a matter of first impression where a court is confronted with fashioning a remedy for an unprecedented type of trespass. In this context, the case is an interesting example of courts fashioning remedies for new types of harms created by technological innovations, in this case, manned balloons. The court reasoned that Guille also was liable because he beckoned to the crowd to come to his assistance, and so is liable for their trespass in entering the enclosure. In that case, they would have been co-trespassers, and we must consider the situation in which he placed himself, voluntarily and designedly, as equivalent to a direct request to the crowd to follow him. In the present case, he did call for help, and may have been heard by the crowd. He is therefore undoubtedly liable for all the injury sustained.